Ari and I are so excited to welcome today our first ever guest on the Sanity podcast, Jed Rubenfeld. Welcome, Jed.
Thank you. It's an honor.
Professor Rubenfeld is a professor of law at Yale Law School. He's a constitutional scholar, and we know he's a scholar because he was smart enough to marry Amy Chua. He also has a tremendous video series on YouTube that I love called Straight Down the Middle, which I really recommend to all of you. To those of you like me who don't have law degrees and you want to understand the most important cases affecting our country today, Jed does a masterful job in Straight Down the Middle, and I really suggest that you check it out. And the last little biographical piece of information I want to share about Jed is that in addition to his degrees from Harvard and Princeton, he also went to Juilliard. And so if we conduct the interview well, Ari, maybe Jed will break out in song, or we'll get lucky. Something like that will happen.
Well, we're in the market for new theme music. So
well, there you go. Something with sun in the name, please.
Right. No chance.
All right, why don't you take it away, Ari?
Well, we're so grateful to have you here, Jed, and mostly because it seems that there's an enormous amount of constitutional and legal ferment happening right now. You know, the phrase constitutional moment or constitutional crisis, as we spoke about last week, is thrown around a lot. But it really does feel that at the beginning of this Trump 2.0 term, the president is really focused on marking the boundaries of his power. And I think I'm surprised by the extent to which the relationship of the president to the federal government and to the executive branch in particular has been an early focus for this administration. So if you could start off just telling us, what are you seeing as the main kind of constitutional themes that are emerging from these first few months of the 47th president's term?
Great question. Yeah. Let me first talk about this term, constitutional crisis, which, a lot of people are worried about. Here's the line in the sand I would recommend that all your viewers watch for, and that's defiance of a judicial order. When that happens, when and if the Trump administration says, well, okay, you ordered that, but we're not going to follow it, that's a tripwire. That's a line in the sand. If we cross that point, I think it becomes appropriate at that point to start worrying about a constitutional crisis. It's the fact that in our country, the administration obeys orders from the judiciary, that it's that little paper-thin line that separates us from being an autocracy or a dictatorship. So you got to be super careful about any time an administration says, look, we're just not going to follow this order. And my feeling right now is that has not happened, and I'm giving the benefit of the doubt to the Trump administration, in part because I know some of the people there, but also in part because he's been president before. And you may remember, and just stop me if I'm going on too long here, but you may remember, like it was week 1 or week 2 of Trump 1.0, where a little district court out in Hawaii said, you know that travel ban? It was being called like the Muslim travel ban. You know what? That's unconstitutional, and issued a nationwide injunction blocking that. Now, there's plenty of lawyers, plenty of law professors who think that district courts in various parts of the country should not have the power to issue nationwide injunctions. It's a non-crazy position to say, we're not going to obey that on a nationwide basis. We think you don't have that power.
And that's come from both the right and the left,
Absolutely.
Right? I mean,
that's not a partisan.
Just to fill people in, a nationwide injunction is where one federal judge can decide a question of national import, and their ruling holds for everybody. And this has come up with the so-called abortion pill, other issues from across the political spectrum.
Ari, you're absolutely right. So that's a nonpartisan issue in the sense that people on both sides have had problems with that, and guess what? They obeyed it. They obeyed it. And by the way, I think that case went up to the Supreme Court, and I think basically that travel ban was, more or less upheld. But they obeyed that district court injunction. They did not. I thought they were going to just defy it, and I thought, okay, here we go, constitutional crisis right from the gate. But instead, they didn't. And what's been happening with these executive orders? There was the most contentious one was maybe that order issued by Judge Paul Engelmeyer of the Southern District here in New York, saying, enjoining DOJ from getting access to Treasury data. And it looked like the order might, some people were interpreting it, maybe it prevents the Secretary of the Treasury from getting access. Well, in one of Danielle Sassoon's last filings in that case, she said, look, we're going to comply with this order, but we need clarification of what it means, but we will comply with whatever you're saying. So so far they are they're complying. And I mean, some people say, well, but they're evading the spirit. Like there was a judicial order saying, this freezing of funds, you got to stop that. You got to lift that freezing of funds. The funds have to start being paid. And so it's true the administration is still holding back on many of the funds that they purported to freeze, but they're doing so under other statutory authorizations. So some people are saying, "Oh, you're evading the court order," but don't forget. I mean, presidents do that. That's what President Biden did after the Supreme Court said, "Oh, that loan forgiveness thing. Well, that was you exceeded your statutory authority." They struck it down, and then he found other statutory bases on which to do the same thing. And so that's not the same as just defying a court order.
So a lot of us, look at these cases and see these district courts that, issue rulings that have import for the entire country, and we can't understand, where that comes from and why it is that way. So maybe you could just give us a little lesson about, has that always been the case, and should that be something that we solve for, or is there something in that offers protection that we want to keep? And then this question of, I'm interested in Ari's initial question about why Trump picked this fight to start with almost, and what you think that means for him and for the country, and where you think the limits of his success should be. How much do we want him to win? Yes,
well, he is potentially revolutionizing the scope of executive authority. I think this is what Ari was asking about, and he is not just like staking out his authority. He is pushing the boundaries of existing limits on executive authority. But none of the points at which he's applying pressure is one that I would call, constitutional crisis material. On the contrary, there are arguments, decent, perfectly good arguments about why the president should be able to fire the people in his administration, rather than having officers or officials who take action that he doesn't want the executive to take, and he can't do anything about it. So there's a perfectly good argument, and the name that this argument goes by is the Unitary executive theory. You'll probably be reading about that, or your viewers may have seen that, but that's the position that says, look, the president has the power should have full power over the executive branch, and Congress shouldn't be able to stop him from, for example, firing people who aren't obeying his will.
Yeah, and I think that is sort of underrated, is the fact that the fights Trump the Trump administration is picking are kind of classical ones. Any sort of 1L con law class, you read about the president's authority over autonomous agencies, the ability to hire and fire, the possibility of taking on the case of Humphrey's executive. I mean, there's a long tradition here, not only of presidents standing up to the courts, and famously Andrew Jackson told John Marshall to enforce his ruling, and there have been other clashes since, but also this question of where the limits of the presidency lie is one that's as old as the Republic.
Right. So sticking with this issue of can the president fire officers. So right now, a case or issue being litigated is, can the president fire this guy Hampton Dellinger, who is the special counsel right now? And that's the case. It's already made it up to the Supreme Court. I don't know if they'll rule on it in its current procedural posture, but it's already up in the Supreme Court, and that's going to test this unitary executive theory. It's going to maybe test Humphrey's executive, but guess what? He's got the conservative justices on his side on this. All their decisions over the last several years have been pointing in the direction of yes, they're going to let him fire this guy and cut back this case that Ari was mentioning, Humphrey's executor, even further than it's already been cut back. And the big ticket item there to watch out for is like the Fed. Mm-hmm. Is it going to be that the president can fire members of the Federal Reserve Board? That's not on the table. He hasn't purported to do that. That's like the big ticket item there. This is a very different case, the Hampton Dellinger case. And I suspect, I don't know if it'll happen in this round, but I suspect he'll win that case. Full disclosure, Hampton Dellinger's son is a student of mine at Yale, and Hampton's father was a colleague at Duke, but I suspect Trump's going to win that one. Mm. But the point is, so those are things he's pushing on, and I think has a very good chance of winning. A different issue is, what if Congress says to him, you can't do something that isn't considered within the sole and plenary power of the president? Congress passes a statute and says, for example, we order you to spend this money on this program. And most people don't think that that's a unitary, plenary, sole power that only the president has, where you're talking where the Constitution gives the president the sole power to do something. Then Congress can't come in and tell him not to. That's the idea of the president having sole and plenary power over something. But most people don't think that's true about spending. They might think that's true about firing an executive officer that wields significant executive power. Most people don't think that's true about spending. So I think he might lose that fight.
Right. And spending is at the heartland of the legislative power, the power of the purse. It's worth wondering, though, into this political moment, whether Congress would be able to assert itself that way. This could come up, though, in terms of Trump's vows or plans to eliminate some federal agencies, right, which have been established by legislative statute. We spoke last week about USAID and in some sense the Department of Education. There I could see those are inter-branch clashes could be coming down the pike.
Yeah, you're absolutely right. That's going to be... So first of all, you got to interpret the statutes that have been enacted. And so question one will be, do these statutes permit or forbid the president to abolish an agency, abolish a department? There was a statute some decades ago that gave the president reorganization power. This term reorganization just means getting to abolish, reduce the size of, eliminate completely an agency or a department. And that statute was around for a while. It had a complicated procedure to it, but it doesn't exist anymore. So a lot of people think the president does not have the power right now to eliminate a department, that the statute that created the department doesn't give the president that power. But that's the first question. Does the statute permit the president to get rid of it? If it doesn't, is that a core plenary presidential power? Can Congress stick him with an agency, a department that he doesn't want? So far, there's no decided cases that strongly suggest that he's going to have that power regardless of what the Congress wants to do about it. So that's going to be another very important site of contest.
Can I just ask you a question about the spending? I'm curious about this. If the president, I guess we're about to find out if the president can or cannot cancel congressional allotments to certain agencies, USAID. But if they assign $50 million a year to USAID, but there's no line item budget, doesn't say where, it's just you get the money. Can the president go in if he finds fraud or sending the money to a third party or whatever they are finding right now, Doge is finding, can he retain the overall budget that Congress assigned, but can he cancel those specific payments to those particular agencies or NGOs?
Well, again, it's kind of a boring type of answer, but you're going to have to look carefully at the statute. So some statutes use the word shall.
That's not the answer I wanted.
No, some statutes use the word may. And it makes a big difference. If the statute says that the president shall spend this money on such and such a program, it's specific and it uses mandatory language, there's no doubt under current law he's got to do it. Now, side note, his lawyers are currently taking the position that no, he doesn't have to, even if it's mandatory. So they say that any attempt by Congress to impose mandatory requirements where he has to spend money, those are unconstitutional. But I don't think they have much in the way of case law to back up that claim. Now, if the statute just says, here's an amount of money, but we're not telling you what to spend it on, was that the kind of question you're asking?
I mean, I'm assuming nobody said spend money on sending Medicare and Medicaid funds to people overseas or giving funds to dead people. So if that's not the specific use of the money that was assigned, can he say, well, clearly there's some fraud here or abuse and I'm not going to spend it in that way?
Yes, exactly. If the statute authorizes a certain amount of money and leaves it up to the president or the relevant agency to decide, leaves them with discretion about where to spend that money, then the president's going to have a whole lot of authority over it. And he's going to say, it's not up to the agency, it's up to me. Mm-hmm. And I am the one who's going to exercise that discretion to decide where this $500 million or $5 billion goes. Mm-hmm. And so a lot depends on what the statute says. Mm-hmm. And statutes can give the president a lot of discretion here.
I'm wondering, though, are we sort of underestimating some of the voices, maybe not in the White House, but in Trump world generally, who are formulating a more confrontational constitutional posture. I mean, you read some of the things that the vice president has tweeted about the ability of judges to restrain the executive seem to me hinting towards a more radical understanding of the relationship of the judiciary to the executive. People in the president's orbit, like Stephen Miller, have also posted to X understandings that seem to me a little more exotic relative to the mainstream of constitutional history. I mean, do you see those voices in sort of, let's call it Trump world more generally, that are agitating for a more confrontational relationship, antagonistic relationship with the courts over the question of restraint of presidential action?
Oh, for sure. And you see this on X all the time. Impeach those judges and don't follow anything they say if they're getting in our way. But look, let's talk politics for a second. He's got a majority in both houses, but not just that, he has 6 conservative justices. This is the wrong time to pick a fight with the Supreme Court.
Right.
They're basically on your side. They're basically going to probably uphold a lot of what you want to do. Now you're going to pick a fight and say, we don't have to follow anything you say. You're going to pick the worst possible fight at the worst possible time. I just don't think so. So I've seen some hints, among some people, and even when it comes to lower courts, and this is what we were talking about before, the correct thing for them to do is to appeal. If they don't like some little district judge somewhere who issues a nationwide injunction, the right thing for them to do is appeal to a circuit court, and to try, if they want to change that rule, the change should come either from a statute or from eventually the Supreme Court. They say, you know what? The District of Hawaii only has power to rule within that district. And then the circuit court, let's say the Ninth Circuit that the Hawaii ruling would go up to, they only have the power to rule within their jurisdiction. You could have jurisdictional limits on every court. The reason why we don't is because then you have problems of non-uniformity. So in California, like a certain federal law has been enjoined, but in New York it's okay, and it all gets very confusing. So the reason why we got to where we are is to try to have uniformity across the country on these federal law issues. But it creates these problems with little judges out in, podunk saying, what.
Well, net, do you think that that's a good thing or not a good thing? Would you, Jed Rubenfeld, abolish that or keep it as it is?
I'm against district court judges having the power to issue nationwide injunctions. The reason why is because it encourages forum shopping, and then everybody runs to the same judge, and that's a bad look and a bad thing for a legal system. And which judge gets to order first, and then and then
the
what
forum
happens?
shopping is really doing terrible damage to people's trust in the judicial system in this country. I think the average person, they look at that and they see it as political.
Yeah, nobody likes that. So for that's what tipped me over to. But there are problems on the other side, problems of non-uniformity and chaos, confusion. Where does an order apply? Where doesn't it apply?
Right.
I think a good example or an issue that sort of brings together a lot of the things we've been speaking about is the birthright citizenship question, right? There's a policy dimension to this. Is it a good thing in general? There's a constitutional element to this. What does the 14th Amendment say? And I think for a lot of critics of the administration, this is kind of ground zero for their allegations that this is unconstitutional, right? But there's also a sense in which it's taking the usual course. It's being enjoined. It's being appealed in a range of circuits. So just losing in court is not necessarily the same, right, as a constitutional crisis.
Oh, completely not. That's standard. Presidents are always losing in court on some cases, winning in some others. This is not a constitutional crisis. I mean, some people see it as an assault on the 14th Amendment. Well, some people see it that way. Other people think that, there's a case to be made in favor of that executive order. Now, I myself think it's unconstitutional. We could talk about that if you want, but it's proceeding in exactly the way it's supposed to. A bunch of judges have already enjoined it and said it's unconstitutional, and now it's going to go up to the appellate courts. It'll eventually go to the Supreme Court, I assume. But that's a standard operating procedure. Nothing wrong with that.
And, judicial long shots have often been the preferred means of changing sort of consensus over time. I mean, if you go back and say, what is something that felt like a twinkle in somebody's eye and eventually was vindicated, in the long run of history, you'd have most issues.
Yeah.
So.
Oh, sure. How about Brown versus Board of Education? Right. It took a long time. But yeah, so I'm in favor of a lot of the executive orders that Trump passed, and this, you can't keep up with them, and that's, I guess, part of the point, part of the politics of it. But I think I support a lot of what he's doing through these executive orders. The Birthright citizenship executive order is the one clear example of one where I think it's crossed a constitutional line. But so far, I mean, there's nothing crisis-like about that.
Maybe we can shift over to another of Jed's specialties, and that's free speech.
Yes, please. Let's talk about free speech.
Do you want to speak first?
Yes.
Okay, go ahead.
No, well, I mean, one of the ways in which I became familiar with your work actually was through the Murthy v. Biden case, which became Murthy v. Missouri. And I wrote a column about it for The Sun at the time. And I don't know what to say. I don't even know where to start, but I think I'm going to start with somebody, again, who's not a lawyer. I was astounded by the violation of our free speech rights in this country. I literally sound naive when I say it, but I was actually astounded that the government could do what it did. And you may want to get into some of the details about the case, but what I wanted to get to was the result, which astounded me even more, that we didn't end up really winning that case. And so my first reaction, and I think I bumped into you at a cocktail party once and sort of attacked you with this question. How is it possible that the government of the United States could violate the First Amendment? In this case, it was demonstrated that the Biden administration had worked with Google and Facebook and other big tech companies to suppress the free speech of Americans on issues, everything from COVID to the Hunter Biden laptop. It was just clear that it had happened. And how is it possible that they could do that and that the penalty is an injunction? Basically, don't do that again. There must be some great legal understanding of this that I'm missing, but that seems like the absence of a great disincentive, or the absence, there's no disincentive there. And why wouldn't they just do it again? Maybe with a different agency or under a different. I was upset about it, to say the least. So I need you to help me come down from the tree I've climbed and explain to me how this is possible.
I'm pretty shocked too. So I don't know how much help I'm going to be to you, but remember, the Supreme Court even threw out the injunction. So in the end, we didn't even get the injunction. But just to take a step back.
Did I misspeak? I thought there was was it a temporary restraining order or an injunction?
There was an injunction issued by the Fifth Circuit.
Yes, okay.
And then the Supreme Court threw it out.
Right.
And I can explain a little bit about that. But what Rebecca's talking about is a case where people sued officials in the Biden administration and the White House itself, Biden himself, for trying to pressure and collude with social media companies to censor protected speech. In my opinion, it was one of the most important free speech cases of the last several decades. What was happening, this is how I sort of started becoming a free speech lawyer again, because as a law professor, I hadn't done that much actual lawyering for a couple of decades. And then I wake up one day and people aren't able to post on social media that COVID might have originated in a lab in Wuhan, China. That's getting censored. It's suppressed. And if you say it a couple times, then they terminate your whole account. Or even
Dear reader, it probably did originate in the lab in Wuhan.
Well, yeah, I mean, and at the time people were saying it certainly hadn't been proven false at the time, and it probably is going to end up being true. But the point is, true or false, how can you not be able to say that, to speculate about that? Or later, you could not say, look, even if you get the vaccine, you can still get COVID. Because at first, the CDC was denying that. If you remember, they were saying, no, if you get the vaccine, you can't get it. It's a vaccine. Right. And it turned out, yes, you could. And we learned a new name for that, breakthrough infections. But for months, you could not say it might have originated in Wuhan, China. You could not say that the vaccines they may not stop you they may not prevent people from getting the illness. So it was crazy. I mean, I was thinking, what country am I living in where, on the main, in the main public forums where people speak, you're not allowed to say certain things? I was shocked. Now, I started publishing some articles like 5 years ago saying this is a First Amendment problem. And people were saying, well, but the First Amendment doesn't apply to private companies, which it does not. And they were saying, well, this guy claims to be a Yale professor. Doesn't he know anything? And I said, yeah, of course, it doesn't apply directly to Google or Facebook or Twitter as it was known then. But what it does apply to is if the government is in there telling them what they should censor and pressuring them to censor stuff and colluding with them, conspiring with them, inducing them to censor stuff, then you got a First Amendment problem. And at first people were saying that's ridiculous. There's no reason to think the government's doing that. Of course, now we all know, in part because of this case that Rebecca's talking about, which was, I think, called Missouri versus Biden first. And we now know that that's exactly what was happening. And so the district court in that case, it issued an injunction saying this is the most massive attack on the freedom of speech that perhaps in our nation's history. Right. The Fifth Circuit upheld almost entirely that injunction. And then the Supreme Court reversed it, said there's no standing. Standing is this like technical legal concept about whether the people suing have a right to sue. Do you know that my case is the only case still standing after the Supreme Court threw out the Murthy case?
Kennedy v. Biden?
Yes, Kennedy versus Biden. So my client was Bobby Kennedy. Of course, that suit involves Bobby Kennedy suing the Secretary of Health and Human Services, who is now Bobby Kennedy. Right. So he had to drop out as plaintiff because you can't sue yourself. Yes. So, but there are other plaintiffs in the case, and that case is still alive. But
the difference there being that your plaintiffs have what you would describe as standing.
Yes, and the district court so held, and then the Fifth Circuit reversed. But now, of course, everything's kind of on hold because we got a new administration. What are they going to do? But so we don't know. So I also, full disclosure, am involved in the case you're talking about. I'm a lawyer in the case. I have clients in the case, but I absolutely think it was an outrageous violation of the First Amendment, and I was stunned that the Supreme Court threw it out. And to just finish out the point that Rebecca is making about injunctions, so right now the law is that if federal officials violate your First Amendment rights, you can't sue them for damages. All you can get is an injunction. So if they stop doing it, then they say, oh, no, don't worry, we're not going to do it anymore. The Fifth Circuit amazingly said the government has told you they're not going to do it anymore. So, there's no standing here. So you get these terrible holdings where the government does something for 2 years, violating people's First Amendment rights, and there's no remedy at all.
So now I'm despairing.
Let me ask a dumb question. Why wouldn't like a Section 1983 suit apply? That's the law that allows for monetary recovery, right? For if a government official violates your civil rights. Mm.
Well, you guys know so much. I have to hesitate before I say anything. But so Section 1983 is the general federal statute that allows people to bring to file damages actions for the violation of their constitutional rights. But guess what? It doesn't apply to federal officials. It's only state and local officials, and actually not even state officials. But you can sue them individually. You can sue cities for damages. You can sue state officials and city officials individually for damages, but the one group you can't sue is the federal government, federal agencies, or federal officials under Section 1983. What that's called the alternative is called a Bivens action. Right. You may vaguely remember. So for some constitutional rights, like if a federal official violates your Fourth Amendment rights, you can sue for damages. But the Supreme Court has said not for the First Amendment, so it's kind of surprising.
Should I just live in despair, or do you have some remedy for this? If you were going to wave your magic legal wands, maybe both of you, what could we cook up that would prevent against this going forward, or is it just something we all have to live with? We actually have no freedom of speech at the end of the day?
If the case were still alive and cooking, and right now it's on hold, I would have tried to challenge this holding about there being no damages remedy for First Amendment violations by federal actors. So, of course, I would have tried to challenge that. The injunctive remedy, though, that's where a court says you have to stop doing this. And it declares to the whole country what you have been doing is a violation of the Constitution, and you can't do it anymore. And you know what? I would have been very happy to get that result and have it affirmed by the Supreme Court. You have a Supreme Court holding saying what the Biden administration did for the last 2 years or for those main couple of years during COVID, that should never again happen in this country. I would have taken that in a heartbeat. And we didn't get it. They kicked the case out for lack of standing.
Let me ask you a question about free speech in a little bit of a different key. And this is something I think Rebecca and I may disagree a little bit about. And so let's go to kind of the campus setting. Mm-hmm. And we've seen the Trump administration, I think fair to say, attack the issue of anti-Semitism on campus in a fairly robust way across a suite of executive orders and actions, and part of that, both in terms of coming from the feds, and also we've seen schools move in response. For example, Harvard adopting the IHRA definition of anti-Semitism as part of its settlement with a group of Jewish students. We've seen the administration make moves towards deporting students who express sympathy for Hamas or other terrorist organizations. I mean, do you support that kind of thing? How do you understand the free speech issue as it transpires on campus?
It's a great question, and I think a tough one. I'm a free speech absolutist, and I know Rebecca has written about this too. I refuse to get behind these calls to suppress this pro-Hamas speech. I couldn't be more against it. Those butchers. The fact that if you had told me 5 years ago that our finest universities were going to become hotbeds of anti-Semitism, I'm just going to say it honestly because I think that's what's happened, and hotbeds of pro-Hamas protests, I would have said there's no way, that's ridiculous. That'll never happen. But I cannot get behind people trying to suppress their speech, so I just can't do that. Here's why it's a tough question, though. It's the double standard thing. So for years, the universities were suppressing speech. They were suppressing typically conservative speech. You use the wrong pronouns, you get hauled before a disciplinary committee. I could tell you harrowing tales of how this played out at Yale Law School, where I work, where a kid was hauled before a disciplinary committee and threatened for his whole career because he used words that, if I told you what they were, you'd say, I can't even understand it. But like they were supposed to be racist, which they weren't. But for that kind of non-offense offense, they were threatening him, calling him racist. So when they suddenly flip around and say, well, now there's free speech for that, that's what creates the problem. If free speech is going to be used as if it's going to be a double standard, a hypocritical double standard, where, they suppress the speech of one side and let the speech of the other, that creates a huge problem. And I think that's what people saw during, you remember the hearings with Claudine Gay and the others. That's what people were really reacting to. But as a sort of matter of principle, no, I can't get behind. Like we had a professor, I'm not going to mention her name, but we had a professor in the undergraduate university at Yale who tweeted on October 8th, or maybe even the 7th that night, exulting in that day. And there was a petition signed by 30,000 people. It's got to be fired. And I said, no, you can't fire her. You can't, we're supposed to be in favor of freedom of speech. This is the most awful tweet I can imagine anybody saying, but you can't fire her for it.
Yeah, we talked about those petitions before, and I had told you, I think, that when I went to the University of Pennsylvania, and we've had our own set of issues. I'm not a proud alum, to say the least. But when the petitions were circulated in the beginning to suppress the speech of the people who were saying all the things that I would never want my twin 18-year-olds to have to hear on campus, I refused to sign. Mm-hmm. And just like you, just as disgusted by Hamas and its behavior, but I never want that standard to be used against us in our speech, whether I'm a conservative or a Zionist, and it often is. And so I don't think that these are the remedies, especially if you're a Jew on campus. I think it's a huge mistake to think that you're saving yourselves by suppressing the speech of others. It always redounds back to our, not to our benefit. But just quickly, Ari, I just want to ask one other thing. What I am a free speech absolutist, nearly. On campus, the one thing I do wonder about is the free speech of faculty. Not on their own personal social media pages, but I really don't understand why faculty or in positions of authority and can give grades to students should have the right to join in protests on campus. They can protest 3 blocks outside of campus if they want to, but should faculty have the free speech on campus that it looks like they have, and why isn't anybody doing anything about that? Jed Rubenfeld. Well,
as a faculty member at one of these colleges, I'm probably going to be maybe more in favor of free speech for faculty members than you're suggesting. So I'm not sure about that. But here's what I think in part is going on. There are some competence issues where I think universities can take a hard look and do something where some professor teaches a course, they suddenly name themselves an expert in some area and they start teaching some crazy stuff to their students. And I think universities are permitted to do a competence review of what's being taught in their schools. I mean, there's going to be a clash between that and the traditional idea of tenure. You're allowed to teach whatever you want, so there's going to be clashes about that. But universities, of course, have to have basic competence standards and powers. You can't have a professor who's teaching wrong science or wrong math to the students. And so if basic facts are being misrepresented, I would think universities can do something about that. But otherwise, I might be more
free
in
speech?
favor of
You
free
should be able
speech.
to go to a Hamas parade on Locust Walk at Penn as a professor?
Well, maybe we're focusing on the wrong things. I mean, so one thing, as you know, that was happening at a lot of these pro-Hamas protests is it went way beyond speech. I mean, anytime they link arms and won't let somebody, let's say a Jewish person, have access to 1 inch of the campus,
right,
just 1 inch, that's not free speech anymore. Those people should be instantly disciplined, suspended, expelled. I mean, you can't do that. And that's where people, I think, should be focusing their energies. If all you're telling me is that there was a protest and somebody joined it, you and I might have different feelings about it. But there's tons more that you can do something about, and that they haven't been, a lot of universities haven't been doing enough about.
And that's actually a pretty clear line. I mean, the line between speech and action is pretty clear. I'm wondering, have you been following Amy Wax's suit at the University of Pennsylvania? And it seems to me that she's, and I've interviewed her a number of times, and she seems to be on that double standard track, right, where you can use Title VI and say the way that if you are going to police speech, it has to be done equally. I mean, does that seem promising to you as a litigation strategy? I
don't know enough about the case. I cannot get a clear handle on what exactly they are saying that she did that violated their rules. I mean, we all know certain statements that she made, which just look like assertions of fact as she understood them to be, which have never been refuted, and other statements of her opinions, which I would think would be protected speech. But I have never seen, has the university come out and clearly said, look, this is what she did that violated our rules, that isn't simply the expression of opinion. So I'm confused about that case. The headlines and what you read in the newspapers make me think that she's simply being punished for her speech, which of course I would be against, but maybe there's more to it. I'm not 100% sure.
Yeah. Well, just to say that the double standard approach does seem to me a promising one going forward, given how the indulgence of, just on this example, pro-Hamas speech, which is all fine, but then you can, as you said, under different levels of scrutiny, you can't then crack down on other kinds of speech.
But that could go either way, right? And if they ruled that, fine, you can't have a double standard, but then you can still crack down on, air quotes, hate speech or misinformation or disinformation, I would still be very much unhappy with that result, right? Would you?
Well, I think,
let's fight. All
I
right.
think I'm a little bit, well, not less of a free speech absolutist, but, I think these campuses have real endemic problems around their treatment of Jews, basically. And so I'm interested in every tool in the toolbox to make these schools that I owe so much to and so grateful to have attended livable for an 18 or 19-year-old Jewish student. And if that means that, that Harvard there's the line on what people can say is maybe a little bit tighter than what we would otherwise like in the best of all possible worlds. I think I'm okay with that. I think I'm okay with,
No, you cannot be okay with that.
Not allowing students to carry, a sign that has a swastika equals a Star of David on campus.
Wow.
And these are campuses. I mean, this is not the street. I mean, these are spaces that are supposed to have certain standard and values and expectations. I mean, it's not a wilderness with a free-for-all.
Right,
I mean,
but those that under that same argument, then the Ben Shapiro shows up on your campus with his Israeli flag, and people claim that that's hate speech, and
but that's happening anyway.
Intimidating them.
That's happening anyway. Right. Is the argument.
Right. I'm saying get rid of all of it.
How do you push back?
Don't include the Jews in that crazy. Get rid of the crazy.
Well, the problem with the thing about double standards is you can fix them in two different ways. Right. You can raise the bar or lower the bar. Yeah. And that's what you guys are talking about. And, I would say I might be more with Rebecca on this in the following way. This idea about making people feel unsafe as a basis for suppressing speech on campus. That became a big thing over the last 10 years, and there was speech being suppressed all over the country, including at Yale, on the ground that, well, it made people feel unsafe, therefore suppress the speech. And I was always dead set against that, and now I sometimes hear people trying to make the same argument on behalf of Jewish students at campuses. It makes us feel unsafe when you say X, so you can't say X anymore. And I just think if we start using that as our standard, we will have lost the freedom of speech. Yeah. We will have given up too much.
Just speak to that. I know people are going to be thinking this. People sort of make a line between speech and violence, and then right in between, on the line, seems to be from the river to the sea, that line. Yeah. Some people say that is a call to violence, and some people, don't. So where do you fall on that?
You guys are asking the toughest questions. I mean, it's appalling. It's repulsive. And part of the problem is it masquerades itself as like a liberation cry. And, we're not admitting that we're calling for the extermination of a group. But so, these are all problems. But one good thing about the freedom of speech, one virtue that's a little bit underrated, unexpected, is you get to see what people actually think.
Right.
And, so I didn't know that there were lots of people at Columbia, at Yale, at Harvard, who thought, that Hamas coming in and massacring men, women, babies was good. It's important for us to know that. And so they say from the river to the sea. You might not like me for saying so, but I think they have a right to say it. So
I do like you for saying it. I agree.
But the thing that I'm coming back to with Ari is it has to be even-handed. If it turns out that they get to say that, but the universities keep clamping down on so-called hate speech, from other quarters, that is intolerable. So, and to the extent that's what's driving you, I agree with you.
Yeah, yeah. We're not starting a game at 0-0. We're starting a game at halftime where one side is up by a lot. And so I understand the even playing field, but there has to be a degree of catching up. I think, I think where I come out on this, and the thing about the protests on campus that really horrified me, the more I think about it, wasn't so much the rhetoric, but it was, as you said, Jed, it was the action. It was the signs that said, no Zionists allowed past this point, or no Zionists allowed in this student group. Now, that kind of demarcating of the territory of a campus, to me, it was shocking.
Shocking. And there should be zero tolerance for that.
Yeah.
Those people should be. And here's another problem, which you haven't asked about, but wearing masks on a campus. So you can't tell who's saying what. Now, there's a long tradition of anonymity being protected as a matter of our First Amendment. You're allowed to publish anonymous pamphlets. But it gets to be a problem. And there are places like campuses where you need to know, is somebody a student? You're allowed to police your campus. Is it students who are here? Is it not students? But also this general, so people lock their arms. They prevent some people from getting into a place, but you don't know who they are, and there's no way to tell. And then by the time the authorities get there, they're gone. But I am agreeing with you. There should be absolute zero tolerance. Those people should be instantly disciplined, suspended, maybe even expelled. It's unacceptable.
We have so much to say.
We have so many to be here for hours. This is an unfair question, and you don't have to answer it if you don't want to, but I want you to grade Yale or Yale Law School on its free speech policies, practices, environment right now. And how do you feel personally being there? Do you feel free to say whatever you want? You've been through a few things at Yale, and give us an assessment.
Well, I do express my opinions, so I haven't. I just can't stop myself, basically. So I do, but it's been bad, and the atmosphere on the Yale Law campus, in terms of freedom of expression, reached a very low point a few years ago, where students really couldn't express themselves. It was just sort of peak wokeness, and if students expressed a conservative view, they would be ostracized by many of the students there, and they risked being disciplined, even if they hadn't said anything that came close to any line, and it was terrible. And I will say honestly, our dean contributed to that and was part of that. Now, in the last couple of years, I think things have gotten better. Students tell me that the culture is not nearly as bad, and that they are now able to express opinions. They don't worry so much about ostracism. There hasn't been this disciplining. And of course, administrators are political people. I mean, they see what happened to Claudine Gay, and they're like, time to shift gears here. And so they have. And after the worst of it, some people got fired. And I think things, I'm crossing my fingers, and I'm holding my breath. I'm waiting to see. I don't think it's completely over and done with yet, but I think it has improved.
Okay.
Maybe on that hopeful note, Jed Rubenfeld, thank you so much for joining us.
Thanks for having me. It was a pleasure.
Great to be here with you. Thank you.